Hello everyone. So today we are discussing. We'll start the class with our DPSPs. Okay, so Directive Principles of State Policy. So all this while we saw the making of the Constitution, we saw the salient features of the Constitution, then we saw the preamble, and yesterday we talked about and before that we talked about citizenship. We talked about union and its territories, and now yesterday we talked about fundamental rights, and now we are going to start with DPSPs. Okay. So yesterday when we were talking about DPSPs, you guys must have noticed that they were all conforming to something called as the political democracy. Right? Okay? Political democracy. But now, slowly with DPSPs, we are moving forward to something called as a social democracy. Okay, so this is going to be a journey from political democracy to social democracy. So fundamental rights that we saw yesterday, they protect freedom. Okay. In the grand scheme of themes, they protect freedom. But DPSPs are something that demand justice. Okay. So basically, they are guidelines meant to direct the state in lawmaking and governance. Okay. To establish a just and equitable society by promoting social, economic, and political justice. So, like I said, they demand justice. Now, where are they? They are in the part 4 of the Indian Constitution from Articles 36 to 51. Okay, and they are inspired by the Irish Constitution. Okay, and they help or they reflect the idea or the concept of welfare state. Okay, so on and like I said, on a grand scheme of things, they talk about society at a large. So how should a society be at a large? Whereas rights that we talked yesterday about are with respect to individuals, correct? No person, no citizens. We saw this was the common theme in all of the rights. Okay, we saw where they are located. We saw by which constitution they are inspired, and they are non-justiciable in nature. What do you mean by that is, if your fundamental rights are abridged, you can go to a court. But if the DPSPs are abridged, you can't really go to a court. Okay? But they are fundamental in the governance of the country. Okay? So DPSPs are instructions to future governments, and they are not enforceable in courts, but they are enforceable in politics or policy making. Okay? So this is the distinction that you should understand. Okay, why are they called directives? Because they guide the state. Okay, they are not binding on the state, but they kind of, it is morally right to include them and to make the policies such that they reflect the DPSPs. Okay, and they help India move towards becoming a welfare state. Okay, they are not justiciable, but they act as a moral and political obligation for governments. Now, the types of DPSP. The constitution does not classify DPSP. Okay, if you get a question tomorrow saying that the constitution classifies them as socialist and Gandhian and liberal intellectual, no, the constitution does not classify. It's a classification done by Lakshmikant himself, maybe. Okay, it is in the book. Okay, so we have three types. Okay, socialist principles, then we have the Gandhian principles, and then we have the liberal intellectual principles. So, socialist meaning what? They aim to create a society based on social and economic equality. So, all the DPSPs that sound like this, sound like a society based on social and economic equality, are socialist principles. Okay. Then, with respect to Gandhian principles, these reflect Mahatma Gandhi's ideals and focus on rural development, self reliance, and upliftment of the poor. So, all the articles that sound like this are Gandhian principles. Okay. Then we have the liberal intellectual. These focus on individual rights, international peace, and legal reforms. Okay. Now we will see one by one. So you just need to, once you understand the DPSPs, you will understand which category they belong to. Okay. So instead of learning this, you just learn the DPSPs, and then because you know what it means, then you can put them in that particular category. Okay. So we'll begin with our DPSPs now. So Article 36 talks about the definition of state in part 4. Yesterday we saw the definition of state in part 3, which was given in Article 12. Okay. So for the purpose of part 4, the term state carries the same meaning assigned to it under Article 12 in part 3 of the Constitution. So what does this mean? DPSPs apply to the same authorities जैसे कि the Government of India, Parliament, state governments, legislature, local bodies, and other instrumentalities of the state as the fundamental rights do. So same है उनका. Okay. The scope of responsibility under DPSPs is wide and include all arms and levels of government. Okay. So same. Basically, the term state is same in both part 3 and part 4 of the Indian Constitution. Okay, that's the Article 36. Now, Article 37, application of the directive principles. So, the directive principles are not enforceable by any court. Okay, but they are fundamental in the governance of the country, and it is the duty of the state to apply these principles while making laws and policies. Okay, basic. So, DPSPs, are they legally binding? No. Okay, but they are constitutionally binding. If you are working on the principle of constitutionalism, then you have to ingrain these DPSPs in your policies. Okay, now the Article 38, promotion of welfare of the people. This was added via the 44th Amendment Act of 1978. So there are two clauses. What does the clause 1 say? The state shall strive to promote the welfare of the people by securing and protecting a social order based on justice, social, economic, and political in all spheres of national life. Okay. So clause 1 is talking about the social order based on justice. Okay. The clause 2 is the state shall make special efforts to minimize income inequalities, eliminate disparities in status, facilities, and opportunities, and not just among individuals but also among groups residing in different regions or engaged in different professions. So, clause 2 is talking about reducing inequalities. Okay. So, looking at the text, looking at the content of these articles, you understand that they belong to the socialist group. Okay, you have, I have made these diagrams for you so you can pause and understand from where each belongs. Okay, or it is there in the Lakshmikant also, so you don't have to worry so much about it. Just understand what is the content of each DPSP. Okay, so Article 38 has the idea of the welfare state, है ना? Okay, and India is not just a democratic republic, it is a social democracy in progress. Okay, now we move on to the Article 39. Okay, certain principles of policy to be followed by the state. The state shall directly in its policy towards securing shall direct its policy towards securing the following objectives: equal right for men and women to adequate means of livelihood. Material resources of the community should be distributed in a manner that serves the common good. The economic system should not lead to the concentration of wealth and means of production to the detriment of the society. Equal pay for equal work for both men and women, protection of the health and strength of the workers and of children from abuse and from being forced into unsuitable work. And the children should be given the opportunity to develop in a healthy environment with freedom and dignity and must be protected from exploitation and neglect. This is added in the 42nd constitutional amendment. Okay, so यहाँ पे what do you see? You see an economic democracy, right? Equal livelihood, distribution of resources for common good, prevention of concentration of wealth, equal pay for equal work. Okay, so economic monopoly is trying to be avoided by this article. Now, another important thing that if you remember from our last classes, this is the Article 39B and Article 39C. You have to tell me what is their connection that we talked in the fundamental rights. You have to tell me this. Okay, yesterday we've discussed this, and this is your job now to understand the connection between them. Okay, so this is your Article 39. Now, Article 39A, equal justice and free legal aid. This was added by the 42nd Amendment Act. Okay, the state shall ensure that the legal system promotes justice on the basis of equal opportunity. Okay, to achieve this, the state shall provide free legal aid through laws, schemes, or other means, and ensure that no citizen is denied access to justice due to economic or other disabilities. ठीक है, so the idea behind this is that the justice must not depend on income. You shouldn't be made, put in a position where you have to afford justice. That is not the case. That shouldn't be the case. Okay, and added by the 42nd Amendment. Important. Now, we have Article 40. ठीक है, Article 40 uh, talks about the organization of village panchayats. Just give me a second, guys. Okay, so Article 40 talks about the organization of village panchayats. Okay, so the state shall take steps to organize village panchayats and empower them with necessary powers and authority to enable them to function as units of self government. Okay, so this is basically local self government. And what does this content tell you? This content is about the Gandhian philosophy, correct? Okay, then next we have right to work and education and public assistance. The state shall, within the limits of its economic capacity and development, make effective provisions to secure right to work, right to education, right to public assistance in case of unemployment, old age, sickness, disablement, and other cases of undeserved want. Okay, so they are trying to humanize the policies. Okay, but this is within the limits and limits of its economic capacity and development. So the forefathers, they kept a long achieving goal in front of the governments in future. Ki whenever you reach to that extent, you have to do this for your citizens. Okay, then Article 42, just and humane conditions of work and maternity relief. The state shall make provision for ensuring just and humane conditions for work and maternity relief for working women. Okay, again, this is humanizing the working conditions. Hmm. Then 43rd is living wage and promotion of cottage industries. The state shall endeavour to secure through laws, economic arrangements, or other means the following for all workers, whether in agriculture, industry, or other sectors: access to work and a living wage, decent working conditions, standard of life that ensures full enjoyment of leisure, social, and cultural opportunities. Additionally, the state shall strive to promote cottage industries in rural areas, either individually or through cooperative efforts. Okay? So what you're seeing here, living wage, decent working conditions, standard of life. So basically to a dignity, humanity. Okay? Then you have Article 43A, participation of workers in management. So this was added by the 42nd Amendment Act of 1976. So where all amendments have happened and what all has been added, you have to remember it specifically. Okay? Because questions can come from that area. Participation of workers in management. The state shall take steps by suitable laws or by other means to secure the participation of workers in the management of industry. So these are quite straightforward. You don't really have to, go deep into the jargons of it, but try to understand. Okay. Now we have the 43B, promotion of cooperative societies. This was added by the 97th Constitutional Amendment of 2011. Okay. The state shall endeavour to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. Okay. Then we have the Article 44, which is the Uniform Civil Code for Citizens. The state shall endeavour to secure for all citizens a uniform civil code throughout the territory of India. ठीक है? Then we have the Article 45, which is early childhood care and education via the 86th Amendment Act of 2002. The state shall endeavour to provide early childhood care and education for all children below the age of 6 years. Yesterday we saw कि इस constitutional amendment से there were changes in FR, in DPSP, and FD. This is a good time for you guys to revise that, what we had talked yesterday. If not, then you do a search for this. Okay. Then we have Article 46, promotion of educational and economic interests of weaker sections. Okay. This The state shall promote the educational and economic interests of the scheduled castes, scheduled tribes, and other weaker sections of the society. Protection of these groups from social injustice and all forms of exploitation. Okay. Then Article 47, duty of the state to raise the level of nutrition and standard of living and to improve public health. The state shall, in this regard, the following among its primary duties: raising the level of nutrition, improving standard of living, and improving public health. In particular, the state shall endeavor to prohibit the consumption, except for medical purposes, of intoxicating drinks and drugs which are injurious to the health. Okay, very important. Then, Article 48, organize agriculture and animal husbandry. The state shall endeavor to modernize agriculture and animal husbandry using scientific methods. Okay. Then take steps for preserving and improving breeds and prohibit the slaughter of cows, calves, and other milk and draught cattle. Okay. So, Gandhian principle, right? Don't take a stress for which category they belong to. Okay, once you go through, once you revise, once you understand, it's very easy for you. Plus you have the diagrams given by me and in Lakshmikant also, you have the classification. Then article 48 a, protection and improvement of environment and safeguarding of the forest and wildlife. The state shall endeavor to protect and improve the environment and safeguard the forest and wildlife. Okay. This was added by some amendment. It is your duty to find which amendment that was. Okay. Then we have Article 49, which is protection of monuments and places of national importance. The state shall protect every monument or place or object of artistic or historic interest which is declared by the law to be of national importance and prevent their disfigurement, destruction, removal, or misuse. Okay. Then Article 50, separation of judiciary from the executive. The state shall take the steps to separate the judiciary from the executive in the public services of the states. Important. Because see, why I'm reading these verbatim for you, because the questions come like that. And the questions are this particular article. They'll just give you the verbatim of the article. They'll not tell you which article it is. They'll ask you from which category do they belong. Or are they fundamental rights, or are they फंडामेंटल राइट्स एटलीस्ट यू नो. ठीक है, उनका उनका वर्बटम बहुत अलग होता है एंड देन यू अंडरस्टैंड बिकॉज दे आर नेगेटिव इन नेचर, राइट? बट FDs and DPSPs are quite positive, and then you're not in a position to quite make that difference. That's why I'm reading this out aloud, so that even you understand it while I'm reading it, and you use this as a guide. ठीक है, while you are revising your Lakshmikant or whatever, revising these notes also. तो अगर verbatim मालूम होगा, so you'll understand कि हाँ, this particular thing is a DPSP or it is a fundamental duty. ठीक है. Then Article 51, promotion of international peace and security. Promote international peace and security, maintain just and honorable relations between nations, and foster respect for international law and treaty obligations, encourage settlement of international disputes by arbitration. Okay. What are the other constitutional provisions which reflect DPSP values outside, meaning outside the part 4? Article 335, claims of SCs and STs in public service. While maintaining administrative efficiency, the state shall consider the claims of scheduled castes and scheduled tribes in appointments to public services and posts under the union and state and the states. Okay. Part 16, special provisions relating to certain classes. Okay. And Article 350A, instruction in the mother tongue. The state and the local authority shall make efforts to provide primary education in the mother tongue for children belonging to linguistic minority groups. So again a good time for you to revise the fundamental rights outside part 3. We have talked intensively about this, but it is good time for you to revise it. Okay. Then we have Article 351, promotion of Hindi. Okay, the union shall work to promote the spread and development of Hindi as a language. Okay, in this part. That's all. Now, important thing is that the conflict between the fundamental rights and DPSPs, that is the most important thing. So, which is greater? Sorry. Individual rights or society's welfare. Okay. So, there was evolution. This thing, evolution के साथ we have come to understand which is greater or which is, or are they similar? Okay, we will see that evolution now. So the Indian Constitution aims to balance the individual fundamental rights with socio-economic goals, which is the DPSP of the states. But however, over time the interpretation has led to legal and constitutional conflicts. So इनका evolution अब हम देखेंगे. First case, Champakam Dorairajan case. Okay, so the issue was reservation in educational institutions. Don't stress yourself with the issues. Stress yourself with the judgment. The judgment was that the fundamental rights prevail over DPSPs. So Champakam Dorairajan, sorry, case में the fundamental rights were greater than DPSPs. Okay, 1951. Then Golaknath case. Golaknath case said that Parliament cannot amend fundamental rights even to implement DPSPs. Okay, so the impact was that the fundamental rights were treated as sacrosanct and unamendable. You can't touch them. So they were even more greater than DPSPs according to Golaknath case. Okay. Then the 25th Constitutional Amendment Act of 1971 was done, which introduced an Article 31C. Okay, ये हमने कल देखा है in fundamental rights. So what it said, the laws made to the laws made to implement DPSPs, Article 39B and Article 39C, cannot be challenged, even if they violate the fundamental rights under Article 14, 19 or 31. Okay, and courts cannot review such laws. ये हमने कल बहुत extensively देखा है. Okay, this is basically the concentration of wealth and redistribution of wealth. Correct. So if some laws are made, okay, to prevent this from happening, even if they violate your Article 14, that is equality, your Article 19 and 31, this was based on property. Correct. So even if you say ki ha, this is not in line with my fundamental right, but still it is okay. Okay, and the second part of the 31C was that the courts cannot review such laws. This was also there. This we have seen yesterday. Okay. Then the Keswananda Bharti case of 1973, landmark judgment. Okay, so it said that Parliament can amend fundamental rights, but they cannot destroy the basic structure. And the second part of the 31C, this one, was struck down. Okay, and then the 42nd constitutional amendment was done, which expanded 31C to apply to all DPSPs, not just 39B and C. And DPSPs were given precedence over fundamental rights. ठीक है, so यहाँ पे according to the 42nd constitutional amendment became greater than the fundamental right. Now you have to see the timeline of this. ठीक है, ये time कब हुआ था? During emergency, correct? So emergency के वक्त, of course they are not going to entertain your individual rights, है ना? Okay, so here the DPSPs were far greater. Then finally, in the Minerva Mills case, it struck down the expanded 31C. कि ये जो कह रहे कि now it expands to all DPSPs, that was struck down. But it is okay with 39B and 39C. Correct? That is there. And it reaffirmed that the FR and the DPSPs must be balanced. So there is no greater than, less than. This shouldn't be done. Okay. What should be there? They should be balanced. FR and DPSPs. किसी का पकड़ा ज्यादा भारी, someone is really heavy, someone is really light, ऐसा नहीं होना चाहिए. They are balanced. They should be balanced. Okay. Only Articles 39B and 39C can override Articles 14 and 19, and judicial review is part of the basic structure. है ना? So that you cannot override. Okay. So finally a balancing act was done. Now, fundamental rights without DPSPs will lead to inequality, and DPSPs without fundamental rights will lead to authoritarianism. Okay, that's why you need both. That's why you need the balance of both. Okay. So we saw political democracy, FR. Okay. Social and economic democracy, DPSPs. Part 3, protect the liberty. Part 4, sorry. Part 4 pursues. This is liberty and this is justice. Okay. So if you understand the balance between the two, you understand the Indian constitutional philosophy. Okay. Okay. Now we move on to fundamental duties. Before that, I'll just plug in my charger. Okay. Now, if the fundamental rights protect the citizens from the state, the fundamental duties protect the state from irresponsible citizens. Okay, you can think it like this. We saw the fundamental rights. Rights क्या है? Rights are claims against the tyranny of the state. Duties क्या है? Duties are obligation. Okay. So for a democracy to be working fine, to be working with maturity, it should not only be built on rights. It should survive on responsibility and rights both. Okay. Now, the fundamental duties are a set of moral and civic obligations enshrined in the Indian Constitution to remind the citizens that rights come with responsibilities. They were added by the 42nd Amendment Act under Part 4A, Article 51A, inspired by the Constitution of USSR, and they are not legally enforceable. Okay, but they serve as guiding principles for responsible citizenship and nation building. जैसे DPSPs, they are guiding principle for the states. Fundamental duties are the guiding principles towards the citizens. Okay, location कहाँ है उनका? Part 4A, Article 51. They are added by the 42nd Amendment and inspired by USSR, and they were recommended by the Swaran Singh Committee. ठीक है. So when you see the timeline, right? 76, matlab during emergency. Okay, but the fundamental rights, they were added during the emergencies, but not just to restrict rights, but to remind citizens of responsibility. एक positive connotation है. Now we'll see the background. 1976 Swaran Singh Committee recommended, okay, because there was a need for discipline and national unity among citizens. Okay, so concerns that rights were being asserted without the civic responsibility. The constitution originally trusted citizens with rights, okay, but during emergency, the Swaran Singh Committee, which was set up, they reminded it to guide them. Okay, then the first was this: associated with fundamental duties, the committees are the Swaran Singh Committee and the 1999 Justice Verma Committee, okay, to review the working of the fundamental duties. So what it did, it identified existing legal provisions under various laws like IPC, environmental acts, that could enforce on or promote these duties, even though the duties themselves are not legally enforceable by law. ठीक है? But there are some laws by which the duties can be promoted or could be enforced, okay, but they are not legally enforceable. That is the difference. Now we will see the articles. So Article 51A lays down 11 fundamental duties, okay, that every citizen is expected to follow. मतलब क्या? Is it talking about any person? No. So it is citizen. To abide the constitution and respect its ideals, institutions, the national flag, and the national anthem. To cherish and follow the noble ideals that inspired the India's freedom struggle. To uphold and protect the sovereignty, unity, and integrity of India. To defend the country and render national service when required. To promote harmony and the spirit of common brotherhood beyond religious, linguistic or regional differences, and to renounce practice derogatory to the dignity of women. To value and preserve the rich heritage of India's composite culture. To protect and improve the natural environment, including forest, lakes, rivers, and wildlife, and to show compassion for living creatures. To develop scientific temper, humanism, and the spirit of inquiry and reform. To safeguard public property and abjure violence. To strive for excellence in all personal and collective activity to help the nation progress, to provide educational opportunities to one's child or ward between the ages of 16 and 14. This was added by the 86th Constitutional Amendment Act of 2002. So this is the verbatim of the Article 51A. So to make it just a little bit easier for you, you can group them. Okay, so there are some duties towards constitution and the nation. Okay, secondly, there are duties towards society. Okay, then there is duties towards environment and knowledge. Okay, and finally there is the duty toward children. Okay, so we'll just try to group them. Duties towards the constitution and the nation is this: abide by the constitution, then the freedom struggle, cherish the freedom struggle, then uphold, protect sovereignty, unity, वो सब, and defend the country. Okay. Secondly, we said duties towards the society. Okay. So these duties, the first ones that we talked about, these duties protect the political identity of India. Okay. Political and constitutional loyalty also. Hmm. Now next, towards society, promote harmony. ये वाला. Okay. Preserve the composite culture. Okay. So these rights, the rights give you individuality, correct? The fundamental rights. But the duties remind you of your social coexistence. Hmm. Now next, क्या था अपना? Next was duties towards the environment and knowledge. So this one, to protect and improve natural environment. Then scientific temper, spirit of human inquiry. Okay, safeguard public property and the strive to excellence. ये वाला भी. ओके सो टुडे वी सी इतना क्लाइमेट चेंज के बारे में इतना कुछ कुछ है एनवायरमेंट इज डिग्रेडिंग ये सब है सो आर्टिकल 51 AG मेड एनवायरमेंटल कॉन्शियसनेस अ कॉन्स्टिट्यूशनल वैल्यू okay courts have mentioned have used this in environmental cases a lot MC Mehta ke cases if you see courts have heavily relied on this article okay then duty towards children there is only one added by the 86th Amendment Act okay again लास्ट आई मीन द लास्ट टॉपिक डीपीएसपी में भी मैंने बोला था कि यू हैव टू लिंक इट विद डीपीएसपी लिंक इट विद एफआर लिंक इट विद डीपीएसपी एंड द फंडामेंटल ड्यूटी now we will see the relationship between the fundamental rights and fundamental duties okay now if you say कि there is what happens if there is rights without duties क्या होगा there are only rights but there is no responsibility so there will be disorder correct but what happens if there are duties but without rights okay there is only responsibility but you are not entitled to anything इससे क्या होगा इससे ऑपरेशन होगा ठीक है नाउ वी विल सी द रिलेशनशिप दे आर कॉम्प्लीमेंटरी इन नेचर ओके जैसे fundamental rights guarantee civil liberties like freedom of speech equality and protection of life and fundamental duties they remind the citizen to respect these liberties and uphold national unity and follow constitutional ideals okay so when you're doing these duties you're also respecting somebody else's fundamental right correct your duty is somebody else's fundamental right you have to have this analogy so that's why they are complementary in nature then they have a balanced citizenship so rights without duties like I said ये होगा rights without duties abuse and lawlessness duties without rights can become oppressive okay what is the legal relationship rights are justiciable and enforceable okay duties are not enforceable but they influence judicial decisions they influence your moral obligations all of this is there okay but they are not enforceable and courts use it to interpret restrictions ठीक है now the judicial use of fundamental duties key judgments so you can go through this like I said this is the most important one अगर और कुछ नहीं किया तो MC मेहता very important ठीक है so this is all about the fundamental duties okay now we will go with the um okay now we will go with the amendment of the constitution amendment of the constitution basically means what it means flexibility but इतना भी flexible नहीं है that you destroy it. It is flexibility without the destruction. Okay. See, if the constitution cannot change, it will become irrelevant. Correct. Things that are prevalent today will not be prevalent 10 years down the line, or something else will be prevalent. These are things that were not prevalent 10 years back, or even when the Constituent Assembly was formed. But now there are so many different things that have come into the society. Okay. So if you can't adapt to that change, you will become irrelevant. So, and but there is another connotation. If you can change too easily, you'll become very fragile. Okay, that means you don't have any foundation, you don't have any core, that you are changing too frequently or too easily. So, Article 368 is this constitution solutions to this tension, to this mantra, flexibility without the destruction. Okay, Constitution of India is a dynamic document. To ensure its flexibility while preserving its core values, the framers provided a detailed amendment process. Okay, via the Article 368. So, what is a constitutional amendment? The amendment of the Constitution refers to the formal process by which changes, additions, or deletions can be made to the Constitution of India. This ensures that the constitution remains relevant and adaptable to the evolving needs of society and governance. Okay. Why do you need amendment? Same. Social economic changes, कुछ अगर गैप्स है तो उनको भरने के लिए, कुछ एरर्स है तो उनको करेक्ट करने के लिए, टू स्ट्रेंथन द डेमोक्रेसी or implement important policy reforms, to adjust the federal balance between center and states, and to uphold the basic structure while making necessary updates. कहाँ है? Where is the location? Part 20, Article 368. Okay. So, in how many ways can the Constitution be amended? This we have seen. Sorry. ये हमने देखा है already. कहाँ पे? Union and its territories. Correct? Part 1 में. Simple majority. Special majority of the parliament and special majority of the parliament plus ratification of half of the state legislatures. Okay. सिंपल मेजोरिटी ऑफ द पार्लियामेंट ये वाला जो है, दिस इज आउटसाइड द स्कोप ऑफ आर्टिकल 368. तो 368 में ये दोनों ही है. ओके, दिस इज जस्ट अ सिंपल लेजिस्लेचर. ओके, ये कहाँ पे हमने यूज किया था? आर्टिकल 2 एंड आर्टिकल 3 में. दिस इज गिवन बाय आर्टिकल 4, करेक्ट? द amendments made to the first schedule and the fourth schedule of the Indian Constitution will not be considered as amendment under Article 368. Correct? I hope you remember that. So, what are the key points of Article 368? Clause 1 talks about the constituent power of Parliament. Parliament can amend the Constitution by way of addition, variation, or repeal. Okay, any provision using its constituent power. What do you understand by this constituent power? By special majority. Because for other legislative power, you just need a simple majority. Correct? But to amend the constitution by way of addition, variation, or repeal of any provision, it will use its constituent power. Okay. So when the parliament amends the constitution, it does not act as a lawmaker, it acts as a constitution maker, just for your understanding. Okay. Then the amendment procedure. An amendment bill can only begin with a bill introduced in either of the house of the parliament. ऐसा नहीं है कि खाली लोकसभा इंट्रोड्यूस कर सकता है या सिर्फ राज्यसभा इंट्रोड्यूस कर सकता है. That's not the case. Okay. So to pass, the bill must be approved by a majority of the total membership of each house and at least two-thirds of the members present and voting. So स्पेशल मेजोरिटी क्या होता है? Half of membership of the house plus two-thirds of present and voting. ठीक है? Now, after the parliament passes the bill, it is sent to the president for assent. If the amendment affects certain key provisions, okay, it must be also ratified by at least half of the state legislature. So, what are the key provisions wherein, see, normally ये चाहिए, but if there are certain provisions that you are trying to amend, इसमें you need ratification of 50% of state assemblies. Okay, so what are those provisions? The amendments involving the following. तो ये क्या है? Articles 54 example, president election. 55 manner of election of the president. Then 73 extent of executive power of the union. 62 extent of executive power of the state. 241 high courts for union territories. Then chapters 4 of part 5, the union judiciary. Then the high courts in the states, distribution of legislative powers between the union and the states. Then any list in the seventh schedule, union, state, or concurrent representation of states in parliaments, and this very article. So anything that has a federal nature, because changing this might have a great impact on the states. Correct? If you change something from the seventh schedule, सभी इसमें टुमारो कॉन्स्टिट्यूशन अमेंडमेंट से कि सभी लिस्ट इस लिस्ट के सभी सब्जेक्ट्स गो इनटू यूनियन लिस्ट, then no, it is a major impact. Correct? So that's when you need the ratification of 50% of the states. Okay. Clause 3 talks about the immunity from Article 13. It says that the constitutional amendments are not subject to Article 13, which protects the fundamental rights from being abridged by ordinary laws. Okay. And clause 4 and 5 talks about no limitations claim. So the article states that no amendment, including changes to part 3, can be challenged in court, and it declares no limitations on parliament's amending power. तो ये क्या है? Unlimited है ना? So you wait for it. So this has been qualified by the Supreme Court through the basic structure, which says that the parliament cannot destroy the constitution core feature. So this is not allowed. Okay. Now we will see the types of constitutional amendments. Okay. So firstly, you have the simple majority. Okay. Simple majority matlab what? 50% members present and voting in either house of the parliament. But this is not governed by Article 360. So क्या क्या है इसमें? Article 2, Article 3. Okay. Fifth schedule. Establishment of new states under fifth schedule. Then the citizenship laws, elections to parliament or state legislatures. Okay. Then by majority of the special majority of the parliament, वो जो formula हमने देखा था, amendment to fundamental rights, DPSPs, changing, not affecting the federal provisions. Okay, this is under Article 368 clause 2. And by the special majority of parliament plus ratification, ये क्या है? Federal in nature. जैसे इलेक्शन ऑफ द प्रेसिडेंट, डिस्ट्रीब्यूशन ऑफ पावर्स 7 शेड्यूल में, representation in parliament and the article 368 itself. Okay, procedure क्या है? Now we will see. Initiation of the bill. An amendment can be initiated only by introducing a bill in either house of the parliament. It can be introduced by a minister only. No, it can be introduced by a minister or a private member. And no prior approval of the president is required. ठीक है? Then the passing in each house. The bill must be passed in each house separately by a special majority. Okay. What do you mean by that? A majority of total membership plus 2/3. Same. And is a joint sitting permitted? No. Joint sitting is not permitted. Even if the house disagrees, there is no joint sitting for constitutional bills. Then if state ratification is required, so if the amendment affects certain federal provision, then the bill must also be ratified by at least half of the states by a simple majority. ठीक है, वहां पे there is simple majority. Now the states don't have to sit with a special majority. And as soon as the 50% states agree, it can go to the assent. The rest of the states are not really mattered here. Then you need the assent of the president. After being passed by both the houses separately and ratified by the states if needed, the bill is sent to the president. The president is bound to give the assent. He must give the assent. He cannot withhold or return the amendment bill. This was added by which amendment? Question for you. Okay, so once the president gives the assent, the constitution bill becomes the constitutional amendment act and the constitution stands amended accordingly. Okay, it is the same procedure. Now there are limitations. Like I said, the unlimited power jo what was being talked, it has been limited now. Though the Article 368 grants the Parliament the power to amend the Constitution, this power is not unlimited. It is subject to the basic structure doctrine. Yes, you can amend, but it is not unlimited. You cannot go amending everything. You cannot you cannot destroy the basic structure fabric of the Constitution. This was laid in this case. Okay. So the parliament can amend any part of the constitution, including the fundamental rights. So can it amend the fundamental rights? Yes. है ना? But it cannot alter or destroy the basic structure. This doctrine was introduced to maintain the core identity of the constitution and protect the democratic values. Okay. So the Article 368 gives power and the basic structure gives the limits. So Keswananda Bharti laid the basic structure doctrine and said that the Article 368 is not absolute. Then the Minerva Mills said that the struck down the clauses of the 42nd Amendment that removed the judicial review and declared Parliament's power unlimited. Both violate the basic structure. So the unlimited power violates the basic structure, and this removal of judicial review also violates the basic structure. Then IR Colo case. Any law, even if placed under the 9th schedule, is subject to basic structure if it affects the fundamental rights. Okay. The 99th Constitutional Amendment was struck down because it violated the independence of the judiciary, the NJAC case. Okay. So the Constitution can be amended, but it cannot commit a constitutional suicide. So this gives us a good background to open the basic structure. So the basic structure, has it been written in the constitution? No. Okay, the basic structure is not written in the constitution, it is discovered by the Supreme Court. Okay, kaha it was laid down in the Keswananda Bharti case, correct? To ensure that the parliament's power to amend the constitution under article 368 is not absolute. Okay, what do you understand by basic structure? It refers to the core principles and values of the constitution that cannot be altered or destroyed, even by a constitutional amendment. It acts like the foundation of the constitution, and you can renovate the building, but you cannot break the foundation. Okay, इसमें we will see. Just give me a second, guys. Okay, now why do you think this concept was needed? Why do you think this doctrine was needed? Okay, if the parliament has the constituent power, which is like an immense power, who controls the parliament? Who controls? The judicial review controls the power parliament, correct? Okay, and the basic structure controls the constitutional amendments. Okay, we will see the evolution of the basic structure now. First case was Shankari Prasad 1951. Here what was said, the parliament can amend fundamental rights, and article 13 applies only to ordinary laws and not constitutional amendments. So here the amendment power was unlimited. Okay, then Golaknath 1967. Parliament cannot amend the fundamental rights, and the constitutional amendments are laws under article 13. So here the parliament power was restricted. Okay, and this created a political tension. Then the 24th Constitutional Amendment Act was promulgated. Okay, it overruled the Golaknath, and amendments under Article 368 are not subject to Article 13. To matlab kya? Judicial review is not allowed here. Okay, so again Parliament's power became unlimited. It regained that. Then came the Keswananda Bharti case, the landmark. The court says that Parliament can amend any part. Yes, you can amend, but you cannot destroy the basic structure. Okay, so this is the judicial statesmanship. Okay, and this sounds mature also. That हाँ तुम कर सकते हो, तुम amend कर सकते हो. See, because the need of the society is you need to adapt to it. Okay, but you have to have some core values, you have to have some foundation that you are adhering to, that you are not leaving. Okay, then the testing of the doctrine. 39th amendment, PM selection was put beyond judicial review. Then the Indira Nehru Gandhi versus Raj Narayan case, it struck down the 39th amendment and held judicial review is a part of the basic structure. Okay, then the 42nd amendment, it tried to remove the limits on the amending power. Okay, so again unlimited karna chaha. Minerva Mills case, it said again reaffirmed the limited amending power and judicial review as part of the basic structure. Okay, then came the Vaman Rao case. It clarified that the basic structure doctrine applies to amendments made after this date, which is the Keswananda Bharti date. Okay, कहाँ पे? 9th schedule में. Okay, so anything that is put in the 9th schedule is free from judicial review. ओके, बट वामन राव ने क्या कहा, ठीक है, ओके, दे आर फ्री फ्रॉम जुडिशियल रिव्यू, बट इट अप्लाइज टू दिस डेट. ओके, अगर बेसिक स्ट्रक्चर डॉक्ट्रिन उनका इज बीन अब्रिज्ड, then judicial review is there. Okay, so IR खोलो, same thing. Even if the laws placed in the ninth schedule are subject to judicial review, they are if they violate the basic structure. Okay, NJAC case struck down the 99th constitutional amendment. Okay, so basic structure ऐसा नहीं है कि एक केस आया, I mean हाँ, basic structure doctrine was laid down in the case 1 and the Bharti case, but उससे पहले से and उसके बाद भी these uh, it is a constitutional journey basically. Okay, since there is no exhaustive or there is no final list that you say कि हाँ इतना बेसिक स्ट्रक्चर है, it is kind of an non exhaustive list. जैसे the it is evolved through the judicial interpretation, correct? So क्या क्या है, supremacy of the constitution, sovereign democratic and republican nature of the Indian polity, secular nature, federal nature, ऐसा ये लिस्ट है. Okay, you go through this. Equality, balance between fundamental rights and DPSPs, limited power of the parliament to amend the constitution. So basically what you have to think कि जो भी positive है comes under the basic structure. Okay, free and fair elections, independence of the judiciary, judicial review, which will positive in the sense non-arbitrary. Okay, so it limits the power to amend, not the power to govern. And basic structure does not freeze the constitution, it protects its identity. Okay, iska what is the relationship of basic structure and article 368 that we saw amendment of the constitution? Okay, article 368 gives the power to amend. Okay, but the basic structure gives the limitation to amend. Okay, kind of a discipline. Okay, so without the basic structure the constitutional amendment would become unconstitutional. That's the basic idea of it. Okay, so we covered 4 topics today, and I hope you revise, I hope you keep studying. Thank you.